Hello guys, this is Olayeni, Dear Kolola Daniels, and welcome to another episode of Dear Ko Talks Law. On this particular episode, we'll be talking about the third rule in relation to the first element, which is the fact that for you to succeed in a claim of battery, there must be physical interference. In my last 3 sets of classes, I have defined battery, and also I have told you about the elements you need to prove to succeed in a claim for battery, both the compulsory element to be proven and the non-compulsory element to be proven. And also, I have told you through the first rule that the slightest touch would amount to battery. The second rule, the contact or the touch could be direct or indirect. Now in this class, we are going to look at whether or not omission would amount to battery. And this is going to be the last thing we will discuss under the first element to be proven in battery. If this is your first time of coming to my channel, please make sure that you watch all these videos before you watch this particular class so that you don't get lost. Do you understand? If you check the description box below, I have kept the videos in the description box, the link to each of them. Please make sure you click them, you watch them, and be fully abreast about what we are talking about before you watch this class. Secondly, if this is your first time of coming to my channel, please make sure that you click the subscribe button, make sure that you click the notification bell, so that if I release a video which is going to be of interest to you, just like this one, you'll be one of the first set of people to watch that video. Then lastly, please make sure that you follow me on LinkedIn at Dear Kolola Daniels. Make sure that you follow me on LinkedIn. There are a lot of things that I'll be posting on LinkedIn. I have been posting on LinkedIn that's going to be of help to you. So we move straight into today's class and the note. An omission may amount to battery. Now, an omission, especially if it persists, may amount to battery. For instance, a motorist who accidentally drove his car onto a police constable's foot while parking his car commits no battery, but he commits battery if he ignores the constable's plea to get off my foot. Now, this is just the fact of the case of FAGAN versus Metropolis Commissioner. Now, the defendant was reversing his car whilst the complainant police constable standing in his front indicated where he should park. He drove the car onto the policeman's foot and stopped thereon. The constable told the appellant to get off his foot, and he received an abusive reply. The constable repeated this request several times, and the appellant finally said, "Okay man, okay," and slowly reversed off the constable's foot. He was charged with assaulting a police officer in the execution of his duty. The court held that the plaintiff was liable and his appeal was dismissed. The appellant's conduct could not be regarded as mere omission or inactivity. There was an act of battery which at its inception was not criminal because there was no element of intention, but which became criminal from the moment the intention was formed to produce the apprehension which flowed from the continuous act of being on the complainant's foot. All the grammar that we've been saying, this is what it is. Now, you are driving your car. LASMA stopped you in front. If you're in Lagos, you know LASMA. I don't know about other states or other, countries, but if you're in Lagos, Nigeria, you know LASMA, they are the people that control, traffic on the road. LASMA stops you, and when you stopped, you didn't know because the LASMA moved to the side, but the LASMA was stupid enough to have kept his foot beneath your car. That's the tire. Now, you didn't know when you stayed on the last man's foot, and I told you in the first video, the first lecture, for you to succeed in a claim of battery, there are 2 things. Not only must there be physical interference, which could be indirect, as in this case. In this case, it's indirect because you used this car. He did not touch the last man physically. So we can establish that, yes, there has been physical interference. But secondly, we haven't established the fact that that physical interference was intentional, which is an element to be proven. So Lasma was standing, you then drove, there is no intention. At that point, there is no battery. But Lasma now told you, wait, you are staying on my leg. wa moto e kúrò lórí ẹsẹ̀ mi jàre. That's, take your car away from my leg. So the last man said that you should take your car away. Do you understand that, it's, paining him and all that. And then you're like, hey, be the mason, lady. This is where I will sleep. Last man, you just start. Anywhere in the last man. Okay? Then, you started wasting time. Now, note that when you committed the act of driving on the last man's foot, there was physical interference, although there was no intention. Therefore, there was no claim of battery. But where you decided to remain, which becomes an omission to act, which is also an inactivity, when you decided to remain on the last man's foot, that is an omission to act. From there on, there is battery. So yes, an omission can amount to battery. Do you understand that? That's basically what we are talking about. So you say, yes, that's when you now know, hello, sweetie, we'll come and be by. If you're not Yoruba, he's calling his wife and he's telling his wife that there's someone here who said I parked on his leg. And then that's when he decided to do other random things. Why the last man was shouting, you parked for my leg now, come on this car for my leg. And all that. But it wasn't any of your business, And then later you then drive the car, because eventually you then drive the car out of the last man's leg, and then the last man takes you to court. And then you're like, my lord, for there to be battery, there must be an act. And that act must be followed by intention. My lord, as at the time I drove on the last man's car, there was an act, yes, but that act wasn't followed by intention, and that cannot be said to be battery. And my lord, there is no authority that says that an omission to act would amount to battery. And then my lord tells you, no, that's where you get it wrong. Law school, if you went to school at the time you were supposed to, you would know about the case of FAGAN and MPC, which tells you that where there is an omission to act, it will still amount to battery. So with that, we have discussed everything that we need to discuss on the first element, the physical interference, where you must prove that when you want to succeed in battery. In my next series of classes, we'll be talking about the second one. When you are talking about an intention, what would form an intention in relation to battery? Would negligence also come under the element of intention? When someone negligently acts, might not be intentional, but negligently acts, would that be an element that can be proven to succeed in the case for battery? Would recklessness also be an element? These are questions that we're going to be talking about in my next series of classes. Please make sure that you click the subscribe button and click the notification bell, so that when I release those classes, you'll be one of the first set of people to watch it. I hope that you enjoyed my lecture. Don't forget to follow me on LinkedIn at Dear Colola Daniels. I will see you in my next class. Have a very beautiful day.